People have been using the term culture war for a long time, maybe decades, and I think it started out as a metaphor, but what people have to understand is it's not a metaphor. It is a real war. And just because it hasn't risen to the level of like what we would traditionally call a war, like a shooting war between two organized sides, doesn't mean it's not a real war. And whether or not it ever rises to that level, which at this point we can't really know because it hasn't yet, but whether or not it ever does, we have to prosecute it as a war. And we have to decide on and establish, what are the victory conditions? What would victory look like, and how do we get there? And then we have to prosecute the war by all the means available to us. Whether those are social, or economic, or educational, or demographic, or political, or the other means, the traditionally more warlike means. I think it was von Clausewitz who said that war is just politics by other means. But we could also invert that and say that politics is just war by other means. Politics is just war carried on by, slower means, less direct means, more subtle means. And maybe that's not always the case. Maybe there are some idealized cases where politics is something else than war, something other than war. But we certainly don't live in that case currently. Currently, politics is very warlike. You have irreconcilable differences. You have inimical groups who share deep enmities with one another, who can't get along, who possibly can't even coexist. Trying to occupy the same space and the same institutions, etc. So the conditions are absolutely warlike. And we have to recognize that things like the law, the law exists for a particular purpose. The law exists to establish conditions under which we can cooperate. Now, if it doesn't live up to that purpose, if it doesn't establish conditions under which we can cooperate, or if it does the opposite, if it only establishes conditions under which we must conflict, well, then we're not really living under rule of law anymore. Law is for peacetime, law is for friends, law is for allies, law is for cooperation. It's not for conflict. It's not for mortal conflict. And things like the law of war, that only made sense in a certain limited context even between, let's say, civilized European nations, where those nations were willing, they were essentially engaged, their conflicts were not true conflicts, they were not existential conflicts, they were not mortal conflicts, they were simply a more vigorous form of competition, which is a form of cooperation. And they were willing to abide by certain ground rules, which in many cases would even guarantee their defeat. They were willing to abide by those ground rules, even if it meant their defeat, as long as they received the protection of those rules in turn, and that their defeat wouldn't be too dire or too harsh or too unbearable. Right? So that's what law is. It can make sense even in the context of war. If you're talking about a particular kind of war between particular kinds of factions, but we don't live in that world anymore. So our wars now are total wars. They're wars between inimical enemies who, have utterly irreconcilable interests and values and everything else. And so we need to do some serious thinking about the purpose of law and the practice and exercise of law and that, its fundamental purpose isn't really served. And the conditions that give rise to rule of law don't really pertain. And we have something I've talked before about anarcho-tyranny. We have a situation where the apparatus of law, whether it's law enforcement or the judicial institutions, the adjudication of law, those institutions have largely been co-opted by our enemies. They largely serve our enemies and not us. So when I talked to the feds the other day, they were adamant that they give equal time and equal resources and equal attention to leftist violence as they do to right-wing violence and potential right-wing violence. They were adamant that they take that just as seriously. Now, I don't know whether that's true or not. I don't have access to that information. I know that they do take it somewhat seriously. There were feds in Portland going around scooping people into unmarked vans. Some of that stuff did happen last summer. But whether it's equal or proportional to what they do with the right wing, I don't know. But what it definitely isn't, and this is empirically observable, is it wasn't adequate. Because all that stuff went on and on for the better part of last year. It was going on for months and months and months and months and months with no abatement, with no appreciable reduction. Now, there may have been a reduction at one point, which was when the media stopped covering it. Like, at first, the media were boosting it and amplifying it and giving it all this attention, and that was causing it to increase. And then they just kind of stopped at a certain point, and it was just kind of not mentioned after that. Just never really made the coverage at all. And that certainly created the perception that the violence had abated, and I think it probably abated somewhat as a result as well. Maybe a good bit, just because it wasn't getting the attention. And it wasn't foremost in as many people's minds. But as far as measuring the effect of law enforcement activities on that lawless leftist violence last year, it certainly wasn't adequate. Whether there was an effect or not, it wasn't enough of an effect. So you have a situation where our enemies can run amok. Our rivals can run amok in that way and in many other ways. And there aren't really consequences, or there aren't enough consequences for that. But on the other hand, we are zealously policed. Whether it's, the McCloskeys, who are charged by a leftist district attorney for merely defending their own property, or Kyle Rittenhouse, who is charged by a leftist district attorney for merely defending his own life. The law enforcement apparatus is aggressively employed and overzealously employed against us. And in many cases, even the adjudication apparatus, the courts and whatnot, uphold that. So there's definitely a disparity or a disproportionate use of these institutions against us and not against people who are threatening us. So these things don't protect our rights. They don't protect our property. They don't protect our safety, etc., but exactly the opposite. Now the question is, how do we turn that around so that we are prosecuting a quote-unquote culture war, not a real war, rather than having one prosecuted against us? How do we turn anarcho-tyranny around against our enemies and not against us? And the only way I can figure, or the most reliable way I can figure, is jury nullification. And you can learn more about this on the Fully Informed Jury Association, FIJA.org, or by reading Lysander Spooner's essay on the trial by jury. And the basic idea is, if a law is unjust, the jury doesn't have to convict. So if you're on a jury and they bring a guy in and, let's say he's charged with sabotaging a data center for some big tech company. Well, if the law doesn't address the real issues, like maybe that big tech company is engaged in systematic oppression of the American people, and you feel that guy was only engaged in defense of the American people and our traditional constitutional rights, that's obviously not reflected in the law. The law doesn't allow that as it's written or as it's historically been interpreted. But if you are on that jury and you believe that that's an inadequacy in the law or a deficiency in the law in terms of how it's written or how it's been interpreted in the past, then you don't have to convict. You don't have to find him guilty. You can find him innocent and at least hang the jury. That's a hung jury is, when the jury can't come to a unanimous conclusion. And I guess that would lead to a mistrial, and they would have the opportunity to try him again. But every time they do a trial over, that's more expense, more time, more trouble. And the harder you can make it to secure a conviction, the less likely they are to pursue that conviction. And jury nullification is a way that you can do that, because if only 5% of jurors will not convict in a particular case, then that means 50% of juries, if they're randomly constituted, and now they're not, so they do jury screening and jury selection. So you definitely, if you're called to serve on a jury, you don't want to let on that you understand jury nullification or you intend to use jury nullification, because that's an automatic exclusion from the jury. But it is a right that juries have, and it is a right that jurors and potential jurors should be aware of. And if you intend to exercise it, you might not want to make that fact clear, or even let on any hint whatsoever that you understand or intend to exercise that right. That's why this is called the Fully Informed Jury Association, because they don't inform jurors of this right as part of the jury selection process. And if they get any hint that jurors understand this right, you're out of there. You're not going to be on the jury. So you have to keep your cards close to your chest if you intend to exercise this right. But if we can get to the point where 5% of jurors understand this right and can make it through a jury selection process without revealing that they understand this right, then conviction becomes a 50-50 prospect. If we can get that number up to 10%, then conviction is it's only a 25% probability. So the effects are huge, and it only takes a minority of people to achieve those effects, which is important because our enemies are democratic. Our enemies are, the teeming hordes, the lowest common denominator. They assemble the coalition, they assemble the cheapest majority coalition for their, power block. The cheapest 51% of the votes. That's always their goal. They never want to get more than 51% of the votes, because that just means that they could take more and give less and still win an election. You could create a platform that would get 60 or 70% of the votes legitimately. You could create that platform. But that platform is too fair. That platform is too benevolent. And it's not the most politically profitable platform, because you could amend that platform to take more and you're going to lose those people's votes, and give less, and you're going to lose those people's votes, but still get a winning electoral result of more than 51%. So if you're getting more than 51%, you could take more and give less and still win the election. That's why they're always looking for a bare victory of only 51%. That's why, even though the Republicans are the worst opposition party in the history of the world, the most ineffectual and the most corrupt probably ever, they're still always kind of in the game because they're still always close to a majority of the vote. And every now and then, the Democrats screw up and overplay their hand and take a little too much and give a little too little, and then the Republicans can get it for a few years. Now, they never do anything with that, but that's why they still seem like they're in the game. It's not because of any great talent or ability on their part. It's because the Democrats know that the smallest victory is the most profitable victory, and they're always aiming for the smallest victory. And sometimes, they get it a little too small and it ends up not being a victory at all. But my point is, they're always aiming to assemble the cheapest coalition, which means the smallest coalition and the cheapest coalition. And the cheapest coalition is the most worthless and parasitic coalition. Because if you have somebody who's at rock bottom and all they want are the bare necessities of life, then you can buy their vote for a relatively modest sum, right? But if you have somebody who's on the top of their game and is just killing it, and life is good and everything's going great for them, their vote is pretty expensive, right? Their vote is pretty expensive because there's a lot you could take from them. And you have to not take a lot of it in order to get their vote. So in other words, you have to give up a lot of potential plunder to get their vote because they have a lot to plunder, right? But with that plunder, if you did that plunder, you lose one vote, big whoop. You can go out and buy a bunch of votes from worthless, low-life bums, right? Does that make sense? So the cheapest votes are the most worthless and parasitic votes. But they all count the same. So if you're trying to assemble the smallest possible coalition and the cheapest possible coalition, you're going to end up with about 51% of the most worthless people in society. And of course, like the very tippy top, the very cream or the scum, depending on how you view things, depending on what you consider floats to the top, those people are going to be well represented too because they're the donor class, right? And they're the people who can afford lobbyists, and they're the people who make a lot of donations, and so their interests are going to be well represented because of that. And you have the people at the very bottom; their interests are going to be pandered to because of that, and then everyone in the middle is just kind of screwed. We're just kind of screwed, but we can get 5% or 10% to understand this jury nullification thing, that can achieve a measurable result in terms of these parasites who play this high and low against the middle game with us using the political institutions, getting them so they can't secure a conviction against us. So they can't prevent us from fully participating in this war that they're waging against us. Then it becomes no longer a one-way war. Then it becomes a two-way war, right? Because once the rules are suspended, and they're already suspended for us because they don't protect us, they only work against us. But once the rules are suspended for them too, then we can have a real conflict where both sides are fully participating and are able to achieve something on behalf of their own interests. So that's what I think a big thing we should be focusing on is this jury nullification and fully informed jury association has a lot of good material. Lysander Spooner wrote a lot of good stuff about this. That needs to be a big focus for us, because it turns this from a one-sided war into a two-sided war. It's not just our elite and underclass enemies using the institutions to wage war against us. Then it's a real two-sided conflict where both sides are participating on equal terms, meaning the terms aren't skewed against one side in particular. They don't disarm and bind one side only and not the other. And then maybe we can ultimately get to cooperation. Then maybe we can get people to agree to terms and agree to rules under which we can cooperate. But they're not going to do that now when the rules only serve them and only hinder us and only bind us. They're not going to agree to terms under which we can cooperate when they have rules now and terms now where they can do whatever they want with impunity to us, but we can't do anything back to them. So they're not going to agree to good terms when they have terms that are bad but favor them currently. So this jury nullification can move things to a situation where there are no rules. There are no holds that are barred. And then maybe they will consent to good rules, if we don't want to prosecute the war to actual completion. Let's talk a little bit about law in general. Now, a lot of people think law and legislation are the same thing. They're not. Legislation is written by Congress, essentially. It's more of an edict or a proclamation or something like that than a law. Law is nothing more or less than the rules that are necessary for cooperation. And traditionally, in the English system, the common law system, and in the Germanic system more generally, those laws were not written. They were discovered. They were discovered by judges and juries and applied, codified in terms of precedent, past legal rulings, and then to be applied in future legal rulings. And it's not necessarily the case that there's only one way to conceive of or formulate those laws. There could be several valid legal systems, right? But it is the case that once you have a working legal system, then that constrains what other laws can be incorporated into that system. But it is a good system because it's adaptive. As circumstances change, the rules that are necessary for cooperation will change. And so as judges and juries identify new cases, let's say based on new circumstances or new technologies or whatever, where, somebody is, let's say, profiting illegitimately at the expense of another, then you have a new kind of crime or a new kind of parasitism that arises because of those new circumstances, those new conditions. And judges and juries can make a determination in those new cases. And so the body of existing law can evolve rather rapidly to reflect new circumstances. And it doesn't have to be explicitly codified by some august body of men. It just arises in a distributed fashion from courts, many judges and many juries all over the place, adjudicating new controversies as they arise. So it's rapid, it's responsive, it's evolutionary, it updates and adjusts to new circumstances and new conditions. And that's very much in contrast to the legislative process, where maybe you'll have, Congress might anticipate some kind of coming issue as, let's say, conditions are changing. They might anticipate that there's going to be some kind of issue or conflict or controversy that arises from some change in conditions. Like, maybe the development of the internet. They might anticipate that that's going to lead to some new kinds of controversies or conflicts. But they're not going to act on that anticipation. And it wouldn't be good for them to act on that anticipation either, because they're probably going to anticipate wrong. They're not actually going to know very well what kind of new issues are going to arise from that new technology, that new medium. And then once issues do start to arise, it takes a long-ass time for them to address those issues. It takes years and years. Like, they've been discussing this big tech stuff in Congress for at least 2 years, and they haven't done anything. And when they do something, it's not going to be good, because Congress is easy to bribe. Congress is easy to corrupt. It's a single point of failure. It's a few hundred guys, and it's relatively easy to influence or corrupt a few hundred guys. Now, the idea with a judiciary under the common law is it's probably a lot more judges than that, thousands of judges nationwide, creating this body of common law or case law or precedent. It's much harder to bribe that many judges, to influence that many judges. And it's even harder still to bribe or to influence juries, because the idea is you're drawing juries from a much larger pool, and you're drawing them randomly. And then once they've been drawn, the opportunity to influence them is essentially gone. Or that's how it's constructed ideally. They're supposed to be in seclusion, and so, once the jury has been selected, the opportunity to influence them has been passed. And they're being drawn from just a massive pool, which ideally should include almost everyone, or at least everyone who's qualified. And so those are a couple of the main functions of juries. One is to be uncorruptible, because they're drawn from a massive pool. And when you have a single point of failure, like a legislative body, or even a judiciary, but less so of a judiciary than a legislative body, you can corrupt a few dozen out of a few hundred guys, or influence a few hundred guys a lot easier than you can influence thousands or let alone millions, which is the jury pool. So it's more responsive. It can more rapidly address new controversies, new cases, and it's less corruptible. So those are the advantages of common law over legislation, which is always inadequate and always biased and always late. So that's not law, that's legislation. It's something different than law. Law comes about by different processes than legislation. But here's my point. Law codifies the conditions under which we can cooperate. And that depends on, let's say, an agreement on fundamental values. That depends on a little bit of cultural commonality. Otherwise, if those are too different, if our values are too different, if our cultures are too different, then maybe we can't cooperate. Maybe there's just no way to codify a set of rules under people who are too different can cooperate. And then the issue is not, how do we cooperate, or what's the best system of law for us under which to cooperate. Then the issue is we're at conflict. We're in conflict. And that conflict has to be resolved. And it has to be carried on by a variety of means. I'm not necessarily even saying violent means. It could be a bunch of other means too, nonviolent as well. But that conflict has to be resolved, and that's what jury nullification does. Jury nullification effectively suspends the rule of law. because we don't have juries that can agree on a principle that, oh, well, in this particular case, this is the unanimous agreement for what the proper decision is. So jury nullification suspends the rule of law and allows the parties to engage in a wider conflict outside of the institution and the constraints of law. And ultimately, the best solution to that conflict will be that the parties that are conflicting will go their separate ways. One group of parties that have one set of values will go reestablish law in their own area somewhere else, where they're not trying to inflict that on others who have, a totally different set of values and priorities and interests, who are going to create their own law, where they want to. So the idea is to suspend the rule of law so that people can conflict honestly. And then the outcome of that conflict, at the very least, will be a de facto separation. Because the jury nullification will proceed unevenly. Let's say in red areas. In red areas, you'll still be able to convict leftist terrorists, but you won't be able to convict conservative freedom fighters. And so the result of that asymmetry will be that the leftists leave red areas. That will be the outcome of the conflict there. Now, in blue cities, maybe it'll be the reverse. Maybe you still will be able to convict right-wing freedom fighters in blue cities, but not left-wing terrorists. And so the result there will be that anybody with right-wing sympathies will leave the blue cities because they don't have the protection of the law in those cities. So what will end up happening is, instead of having a unified legal system or system of law, that tries to apply fairly across the board, but actually ends up being biased and unbalanced and asymmetrical, you'll end up with two, or at least two, possibly more, separate systems of law being reestablished in different areas that suit the preferences and interests and values and cultures of the people in those areas. So what I'm saying is the temporary suspension of the rule of law through jury nullification is a necessary measure or period in order to prosecute the conflict to its logical conclusion and to reestablish the rule of law separately for separate groups in separate areas. It's not necessarily a prelude to anarchy or the end of rule of law as such. It's just a temporary measure. Because if there's agreement, if there's wide agreement, if there's near uniform agreement about the basic principles and values, then this kind of common law, precedent law, case law, works very well. But if there's disagreement, it doesn't work. If there's fundamental disagreement, it doesn't work. And that's why fundamental disagreement has to be separated so that the rule of law can be established. And the way to do that is to use jury nullification to temporarily suspend the rule of law so that people can conflict, because law is about cooperation, it's not about conflict. And if cooperation is no longer worthwhile with some people who hold some values and behave in some kinds of ways, if there's no longer any value with cooperation with those people, then we suspend the laws of cooperation and engage in conflict instead. And the ultimate result, the most logical result, the most likely result of that is an informal separation. People's own incentives will lead them to separate and to congregate in their own areas with people like them for maximum safety and maximum benefit. And there they can reestablish rule of law because there is widespread, nearly universal agreement among the people in those areas about what rule of law looks like and what principles it embodies and what kinds of outcomes it leads to. So that's what I have to say about that.